Act. That His Excellency Rigathi Gachagua was persistent, inflammatory, reckless, insightful public utterances over the last 2 years, the details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13(1) and Section 62 of the National Cohesion and Integration Act. Ground 7, reasons, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 45, subsection 1, Section 46, Section 47A, Part 3, and Section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. But for the past 2 years, His Excellency Rigathi Gachagua has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired over the last 2 years is incompatible with his legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua and Keith Ikinu Rigathi, and other close family members and associates as proxies. His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used the companies listed to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Among the companies listed are Spirit Way Limited, Fortis Vase Group Limited, Grand Bypass Apartments Limited, Kuruwitu Properties Limited, the Anansi Collective, Calvary Creed International Limited. These are some of the companies that have been listed by the National Assembly as those that have been used in violation of the provisions of the Constitution. Ground 8, serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. The Sergeant at Arms is announcing the arrival of the Speaker of the Senate, signaling the commencement of the afternoon sitting where the Senate is trying the Deputy President. Now I will hand you over for the live broadcast. My name is Edward Kabasa. Enjoy your viewing.
Tuombe. Ewe Mwenyezi Mungu, tukusihi tutazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Tukuomba tuwajalie tuyatende na kufikiria mambo yote atakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, we have quorum. And we proceed to call the first order.
Order number 1, communication from the chair.
Now, honorable senators, this morning at the commencement of the hearing for the removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, Legal Counsel for the Deputy President, Mr. Ndegunjiru, Learned Counsel, raised a preliminary objection on the legal representation for the National Assembly. Learned Counsel opposed the appearance of Honorable James Orengo, Senior Counsel, who is the serving governor of Siaya County and therefore a state officer. Learned Counsel submitted that the Honorable James Orengo is a full-time serving state officer. As per Article 260 of the Constitution, as read together with Section 26, Subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in any other gainful employment. Counsel further submitted that it would be prejudicial to the Deputy President if the Senate allowed Honorable James Orengo to represent the National Assembly in these proceedings. Counsel drew the attention of the Senate to the President said in the matter of the proposed impeachment of the Deputy Governor of Kisii County, Honorable Richard Munda, in which a decision was taken to bar Honorable Sylvanus Osoro, Majority Whip of the National Assembly, and Member of Assembly for South Mugirango in Kisii County, from appearing as counsel for the Kisii County Assembly. In a submission, Counsel cited Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, as well as the decision of the High Court in Office of the Director of Public Prosecutions versus Orengo, Manduko, and two others interested parties, Constitutional Petition 204 of 2019-2021, KHC 456 KLR 27 April of 2021, where Honorable Justice Ogola found and ruled that the continued representation of the first interested party, Mr. Manduku, by the respondent, Honorable James Orengo, as then was, or another state officer is against the spirit of Chapter 6 of the Constitution for failing to conform to the mandatory provision of the Leadership and Integrity Act. The judge ruled that in that case, there was an inescapable conclusion of conflict of interest in Senator Orengo representing the petitioner, highlighted by the fact that the interested party Mr. Manduku, the managing director of KPA, may at one time be summoned to appear before a committee of the Senate to answer to some of the matters that the petition was being investigated on. In response, Mr. Eric Gumbo, learned counsel for the National Assembly, submitted that Article 77 of the Constitution is the primary law that restricts activities of state officers, and it specifically prohibits a state officer from engaging in any other gainful employment. Counsel further, learned counsel for the National Assembly submitted further that no prejudice has been demonstrated that would arise or be occasioned to the Deputy President by the participation of Honorable James Orengo in these proceedings. Learned counsel for the National Assembly sought to distinguish the decision by Honorable Justice Ugola in the Office of the Director of Public Prosecution versus Orengo on the basis that this case turned on the fact that Honorable James Orengo was at that time a sitting senator before whom the matters in respect of which his client was charged could potentially come for adjudication in the Senate, and that no possibility exists into the current matter with Honorable James Orengo as the governor of Siaya County. In his rejoinder, Mr. Njiru, learned counsel, submitted that Honorable Orengo is the serving governor of Siaya County and therefore a full-time state officer, and by that fact alone is a violation of Article 77 of the Constitution. Further, Mr. Njiru submitted that prejudice is not one of the applicable tests under Article 77 and Section 26 of the Leadership and Integrity Act, but that the only applicable test is whether or not Honorable Orengo is engaged in gainful employment. He argued that the National Assembly had not proved that Senator Orengo was providing pro bono services in this matter. Honorable Senators, Article 77(1) of the Constitution provides that a full-time state officer shall not participate in any other gainful employment. Further, Section 26 of the Leadership and Integrity Act provides that a full-time state officer shall not participate in any other gainful employment, while Section 26(2) defines gainful employment as work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibility of the state office, or which results in the impairment of the judgment of the state officer in the execution of the function of the state office, or results in conflict of interest in terms of Section 16. Having considered the matter, it is important to state that a state officer must inspire confidence. However, it is tried law that he who asserts must prove. In this regard, I wish to observe that the learned counsel for the Deputy President did not adduce evidence to prove indeed and demonstrate that the allegation of gainful employment. In fact, it is somewhat surprising that counsel attempted to shift the onus of proving gainful employment to the National Assembly. That argument is untenable. As to the ruling of the Senate, that barred Honorable Soro from appearing for the County Assembly of Kisii in the impeachment proceeding of the Deputy Governor of Kisii County Government, it is clear that what was objectionable was that Honorable Soro was not only a member of Parliament for a constituency in the same county whose Deputy Governor's impeachment was an issue, but also a high-ranking member of the leadership of the National Assembly, and by extension of the same Parliament before which the impeachment was being undertaken. It was ruled that in these circumstances, it was clear that in the minds of the public, the fine distinctions of the bicameral Parliament would be lost, and their confidence in the impeachment process would entirely be undermined. In the same breath, as rightfully contended by counsel for the Deputy President, it is true that in both Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, no test of prejudice is expressly provided for. It therefore follows that both the contention of the counsel for the Deputy President that his side will be prejudiced by the appearance of Senior Counsel James Orengo and the rebuttal by the National Assembly that no prejudice will be occasioned are moot. Honorable Senators, ladies and gentlemen, having analyzed the preliminary objection raised and for the reason I have given, the preliminary objection raised on the appearance for the National Assembly by Senior Counsel James Orengo is hereby dismissed. We will now hear the response on the second objection raised by the counsel for the Deputy President. Counsel, you have 5 minutes to do that.
Thank you very much, Mr. Speaker, sir. I'll endeavor to respond to the preliminary objection within the time allowed to us. Mr. Speaker, sir, the objection was premised on Rule 20 governing the proceedings that are currently before this House. The rule reads that in presenting its evidence, the Assembly shall not introduce any new evidence that was not a part of the allegations against the President by the National Assembly as forwarded by the Speaker to the National Assembly to the Speaker of the Senate. Mr. Speaker, sir, the context of this rule is important. A true reading of this rule would indicate or would mean that every material that was available before the National Assembly while deliberating the motion that was before it is what is contemplated to have been sent to the Speaker of the Senate. The question, therefore, that we'll be asking ourselves this afternoon is whether there's any new evidence that has been adduced by the National Assembly. Our answer to that, Mr. Speaker, sir, is an emphatic no. And why do we say no? We say no for the first reason that the reference to the letter forwarding the material that came from the National Assembly contained, amongst other items, paragraph 21, which spoke to a report of a public participation that was conducted by the National Assembly. Mr. Speaker, sir, that report was tabled on the floor of the House, was adopted by the House. Deliberations in relation to that report were made. Not a single objection arose. It certainly follows, therefore, that that material from public participation became a necessary part of the material that was considered before the National Assembly. To give it context, Mr. Speaker, sir, in addition to the material that was presented by the mover of the motion to the National Assembly, the honorable members of the National Assembly had their deliberations, which also captured in the Hansard. In that Hansard, material was introduced by way of questions, by way of contribution from the floor of the House. That material, too, forms part of the evidence of the proceedings before the National Assembly. It therefore is our submission that just in the same manner in which the Hansard from the National Assembly forms part of the report that was presented before you, the report on public participation too is an important component of that report. There must have been a reason why that public participation was conducted. In our humble submission, Mr. Speaker, sir, the appropriate test that one would want to apply on whether or not to allow that material to be before this honorable House is the all-celebrated test of relevance. Mr. Speaker, sir, it should not be lost that sitting as this House is sitting this afternoon, it is a quasi-judicial proceeding. It is a proceeding that is also inquisitorial. And so therefore, What is important is that the material that is presented by way of public participation or by any other way is relevant to help the House determine the truth or otherwise of the issues that have been raised for the consideration of this House. How then, Mr. Speaker, sir, do we get to answer that question? Mr. Speaker, sir, I've had a look at the specific document that my learned friend, Mr. Njiru, objected to. And Mr. Speaker, sir, it is an affidavit by one Mr. Peterson Njomo Mushira. Mr. Speaker, sir, Mr. Njomo Mushira says that he followed the proceedings before the National Assembly. He says in particular at his paragraph 4 that he has also had occasion to look at the response filed by His Excellency, the Deputy President of the Republic of Kenya, at part 1.1 of his response. And he says that he has personal knowledge of the items that were contained or that would give clarity to part of the assertions in response by His Excellency, the Deputy President. Mr. Speaker, sir, for context, that part 1.1 is contained in volume 6 of one of the volumes that were presented before you. It is the volume speaking to the response by His Excellency, the Deputy President. At part 1.1, Mr. Speaker, sir, it speaks about a hotel called the Olive Garden Hotel. In particular, at part 1.1.4, His Excellency, the Deputy President, says, in accordance with his instructions, the hotel was sold by executors to a third party. Mr. Peterson Njomo Mushira, on the other hand, says, I have information that could
Counsel
help.
for the National Assembly, 1 minute.
Thank you very much, Mr. Speaker. Mr. Peterson Njomo, Mr. Speaker, sir, then says that he has information which indicates that number one is a shareholder to the company which bought that hotel, and that according to him, Mr. Speaker, sir, he got into a secret transaction with His Excellency, the Deputy President, to buy that hotel. Mr. Speaker, sir, it is our submission that that is material that is relevant for purposes of consideration of the matter that is before this House. Mr. Speaker, sir, I urge that that objection be dismissed. I'm most obliged.
Thank you. Honorable Senators, ladies and gentlemen, we need not take a break. Allow me prepare my ruling. Just give me a minute. I put my thoughts together so that we make progress.
Mr. Speaker, sir, with your kind permission, I was just seeking your guidance whether I need to do a rejoinder because I'm the one who had moved the assembly in respect to the...
Very well. You may go ahead as I put my thoughts together.
Thank you very kindly, Mr. Speaker, sir. In response to what my learned friend has raised, the application or the objection had nothing to do with the public participation as cited. We simply raised an objection that goes to the roots of the ability to enjoy proceedings that will appear fair to all parties. My objection was premised on the non-derogable right to a fair hearing. Council has addressed you that the deponent of that affidavit, one Jomo, was responding to the Deputy President's response. There's nothing that can be far from the truth. And this is a witness who is being brought to panel beat or to attempt to panel beat the case for the National Assembly. The question and the test, Mr. Speaker, sir, is, shall we suffer prejudice? Shall our rights be deemed to have been held? And that is the non-derogable right to a fair hearing. This is not a witness who was before the National Assembly. Where is the source of this information in the document that was submitted to this House by the Speaker of the National Assembly? Where does it sit? Who sits to suffer prejudice if the same is admitted? Is it a state organ or an individual in the name of the Deputy President of the Republic of Kenya? We urge you to uphold our ruling and justice be seen to be done, even to the people following these proceedings. I am most obliged.
Now, Honorable Senators, the second preliminary objection raised by the Council for the Deputy President was that the following documents which were submitted by the National Assembly on Monday the 14th of October 2024 were not part of the bundle of documents of the National Assembly that was served on the Deputy President on Wednesday the 9th of October 2024. These are an affidavit sworn by Mr. Peterson Jomo Mushira, and B, the document of the National Assembly marked as Volume 8A, responses from various government agencies. Counsel for the Deputy President stated that these documents prejudiced the Deputy President's case and amounted to a trial by ambush by the National Assembly. Counsel urged the Senate to bar the introduction of these two documents as they constitute new evidence in terms of Rule 20 of Part 1 of the second schedule to the Senate Standing Orders. Counsel for the National Assembly opposed the preliminary objection raised by the Counsel for the Deputy President. Honorable Senators, ladies and gentlemen, Rule 20 of Part 1 of the second schedule to the Senate Standing Orders provides, and I quote, "In presenting its evidence, the Assembly shall not introduce any new evidence that was not part of the allegations against the President by the National Assembly, as forwarded by the Speaker of the National Assembly to the Speaker of the Senate. As I indicated in my earlier communication, by a letter dated 8th of October 2024, I received a bundle of documents and records of proceedings in the National Assembly in this matter. Thereafter, on the 9th of October 2024, pursuant to Rule 6 and 7 of Part 1 of the second schedule to the Senate Standing Orders, the Office of the Clerk of the Senate sent invitations to appear to both parties. The parties were required, amongst other things, to specify any other evidence to be relied on this matter. I will repeat that. The parties were required, amongst other things, to specify any other evidence to be relied on in this matter. In response to this invitation, on Monday, 14th of October 2024, the National Assembly filed further documentation. Having analyzed the documentation submitted to this invitation on Monday, 14th of October 2024, the National Assembly filed further documentation. Having analyzed the documentation submitted against the grounds for the proposed impeachment, I find that the documents objected to constitute evidence in support of the allegations already made in the impeachment motion as received from the National Assembly. It is noteworthy that the parties were instructed when sending responses to indicate any other evidence to be relied on. Accordingly, the documents being referred to do not constitute new evidence, but form evidence in support of an allegation which was already made. That is why Rules 6 and 7 of the Rules of Procedure permit the Senate to receive witness statements, list of witnesses to be invited by and any other evidence to buttress an allegation already made. What is not allowed is to introduce new allegations or to introduce any evidence that is extraneous to the allegations made in an impeachment motion. In the event, it is my considered view that the affidavit and document marked as Volume 8A being referred to fall within the permissible documents of our rules of procedure. I therefore rule that the objection is hereby dismissed. Now, honorable senators, having dispensed with the preliminary matters in this particular hearing, we will now move to hear, yes, Counsel for the National Assembly.
Mr. Speaker, sir, with your very kind permission and indulgence, we as well on the part of the National Assembly had two quick preliminary issues which we wanted to draw your attention to, Mr. Speaker, sir. They are quick housekeeping issues. If you permit me just in 2 minutes, I may be able to draw them to your attention.
Exactly 2 minutes.
Most obliged, Mr. Speaker, sir. Mr. Speaker, sir, the first one is in relation to the bundle of documents that we have filed before this House to help it determine the matter that is before it. In particular, we have one of our documents, or one of our volumes, Volume 4, as a document presented before this court, before this Honorable House. Mr. Speaker, sir, when we were perusing our documents earlier today, actually yesterday, we did realize that one of the documents in that Volume 4, running from page 135 to 140, appears to have been inadvertently copied just on one part. In other words, in the course of a printing, we missed out the even numbers and just printed out the odd numbers. Mr. Speaker, sir, we have since availed that document. It is not a new document. The only thing that had happened is that we forgot, or rather inadvertently, we didn't get the even numbers printed. We have since done that, Mr. Speaker, sir, and with your permission, we urge that we be allowed to rely on that document. We filed it, Mr. Speaker, sir, and served it to our colleagues, counsel appearing before His Excellency, the Deputy President, as well as to the House, that it may be relied upon. That is the first preliminary intervention that we seek. Mr. Speaker, sir, the second issue is in relation to a letter that we did to yourself on the 14th of October 2024, wherein we sought the help of this House through your office to have summons issued to the CEO of the Ethics and Anti-Corruption Commission for purposes of helping give testimony to matters that are before this House. Mr. Speaker, sir, the reason for us seeking this preliminary intervention is to ask formally that those summons, Mr. Speaker, sir, be issued so that the said witness could attend to help us determine the matters that are before you. We, in our letter, did indicate the specific item that is to testify to, and it is equally our humble plea that an order be made that summons do issue to have the CEO of the Ethics and Anti-Corruption Commission attend as a witness. I am most obliged, Mr. Speaker, sir.
Counsel for the Deputy President, what say you?
Mheshimiwa Speaker, Honorable Senators, with regard to the first request, which I understand to mean that when they were photocopying, some pages were left, we are going to examine that and see what was served on us and what those pages that are now being introduced contain. With regard to summons to ask individuals from the Anti-Corruption Commission to come and give evidence, Mheshimiwa Speaker, honorable members, we draw your attention to Article 50 of the Constitution, which is the fulcrum of a fair trial. And this honorable House is executing a quasi-judicial function of the most weighty nature regarding the removal from office of the Deputy President of the Republic of Kenya, elected by the people of Kenya. Nothing would be more prejudicial than to call witnesses whose statements or affidavits we have not seen. The whole purpose of affidavits and witness statements is to enable the other side, in this case, the Deputy President, to seek legal advice, to give instructions on how best to respond to it. And this Honorable House has fixed 2 days for this trial. And one of the issues we'll be raising is these allegations, and you are going to go through them, against the Deputy President, suspicions, conclusions, on matters that were never referred to DCI in Kiambu Road, who are trained to investigate these matters. Nothing was referred to the Anti-Corruption Commission or any of the other investigative agencies, including money laundering. We strongly object and ask that the record of this Honorable House reflects that if this is permitted for the National Assembly to call witnesses at this stage without first furnishing us with their witness statement and affidavits, the case of the Deputy President will be irredeemably prejudiced. So we object very strongly to that application.
Counsel for National Assembly.
Mr. Speaker, sir, in brief rejoinder to the objection by learned senior counsel for the Deputy President. Mr. Speaker, sir, in the invitation to attend that was extended by this House to the National Assembly, the invitation included a request as to a list of witnesses the National Assembly required summoned. We responded to that request. And Mr. Speaker, sir, all we seek is a confirmation that our response has been actioned. What the learned counsel for the Deputy President is objecting to is not our request, but really it is a response to a request made by this august House. I'm most obliged.
Counsel for Deputy President, do I get it that you have no problem with the first request made by the National Assembly?
Mheshimiwa Speaker, we would want to see those pages. And that time we'll be able to say yes or no. It is the second one.
Clerk, has that document been made available to the Deputy President's team? Kindly, in the next few seconds, make it available so that we make progress. Honorable Senators, if there's any senator who has not gotten that document, you may also let the chair know so that we supply you with that document. Senator Mazayo, Senator Olekina, Senator Miraj, Senator Kavindu, Crystal Asige, Senator Kajwang.
Honorable Speaker, if I may, with your permission, just to highlight one point based on what my learned friends for the National Assembly have said. The letter they refer to is a letter dated the 14th of October 2024. It is addressed to the Honorable Speaker of the Senate by the Clerk of the National Assembly. The letter does not contain any information about any other witnesses being sought. It does not indicate that the Ethics and Anti-Corruption Commission will be asked to produce any other witness, affidavits, or documents. Thank you very much.
Mr. Speaker, sir, if I may.
Just take your seat for a minute. Senior Counsel Paul Mwite, are you in receipt of the document now?
Mheshimiwa Speaker, this document, we are seeing it for the first time now, 3-4 minutes ago. And it has got many, many pages, so we were quickly going through it. And in order to save the time of this honorable House, perhaps you can give us an opportunity to go through these documents, because we need to go through them. Inaonekana kama hii ni ukarabati, but let's go through it. Perhaps if you agree, Mheshimiwa Speaker, perhaps we can get on with the first prosecution witness giving evidence, and as soon as we've gone through this, then we shall come back to you, Mheshimiwa Speaker.
Thank you for your wisdom, Senior Counsel. Now, the other name that has been raised is on the issue of summons to witnesses. Now, if you look at our rules of procedure, more particularly rule number 10, which provide as follows, that the Senate may, at the request of the National Assembly or the President, and in this particular matter, the Deputy President, invite or summon any person to appear and give evidence before the Senate. So the summons that have been sought are in line with the spirit of Rule 10 of our Rules of Procedure. You may attack the evidence when these particular witnesses who have been summoned, if their evidence introduces other allegations, then at that particular juncture, the legal team from the Deputy President, you may raise an issue, and I'll certainly hear you at that juncture.
Permit me, Mheshimiwa Speaker, to place it on record that the rules of this Honorable Senate must and have to be respected. But even above respecting the rules of this Honorable House, our Constitution has to be respected. Article 50, the right to a fair trial, which in terms of Article 25C, Mheshimiwa Speaker, you will remember, you are aware, that is a right that cannot be compromised in any manner. There has been no explanation why the EACC was never asked to investigate the allegations before they were tabled before the National Assembly and before a decision was taken, because the National Assembly cannot investigate criminal offenses. In fact, in implementing Chapter 6 of the Constitution, the Act of Parliament said a conviction is necessary. And now you want to reverse the will of the Kenyan people in electing the Deputy President without him being reported or the matter being investigated or him being convicted. Mheshimiwa Speaker, I plead that you reconsider your exercise of that discretion in permitting witnesses from the EACC to be called in order for the Deputy President to have a fair trial before the Senate. Thank you.
Senior Counsel Paul Mwite,
Mheshimiwa Speaker,
you're actually arguing your case. What I said, there was some invitation that was sent to both parties, and each party was requested to submit a list of witnesses. The National Assembly submitted a list of witnesses with a request under Rule 10 of our Rules Procedure for the Senate to summon. That is the request that has just been made by the National Assembly, and it is permissible and it is within our Rules of Procedure.
Mheshimiwa Speaker, you are
Senior Counsel Paul Mwite, I will refer you to Rule number 30 of our Rules of Procedure, where the ruling of the Speaker is final. So let's leave the matter there. I've made my ruling. Let's make progress, Senior Counsel.
Mheshimiwa Speaker, I agree entirely. You are the one sitting in the seat of power. Your word is final. I have said what I've said. Your rules are subject to the Constitution. I accept your ruling.
Now we'll move to the second limb of this hearing. Honorable Clerk, you may now proceed to call the next order. Summons to issue to those witnesses.
Order number 2, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Now, honorable senators, ladies and gentlemen, we are going to move to the opening statements. Each party will have exactly half an hour to make their opening statement, starting with the Counsel for the National Assembly. Your time starts running from now.
Thank you very much, Mr. Speaker and honorable members of the Senate. Indeed, speaking for us, this is a very momentous occasion in our history and must be recorded as such. The United States of America is 248 years old since its independence, and for that entire 2.5 centuries, no Vice President of the United States has undergone a process of removal by way of impeachment. In a way, we are making history. And for me, it is such an important occasion for the 13th Parliament and this Senate that it will go down in the annals of history that the first impeachment of a deputy president in the Republic of Kenya was undertaken by this particular Senate. And we come here with a lot of confidence that the Senate is not new to the process of impeachment as understood under our Constitution. Indeed, the Senate has handled so many impeachment proceedings in relation to the offices of governors and deputy governors. And more importantly, that this Senate has been a great contributor in establishing the jurisprudence revolving around the impeachment process in the Republic of Kenya. Many of the cases that have gone for determination in our system of courts, High Courts, Court of Appeal, and the Supreme Court have involved the participation of the Senate. So as we address you today, we are not addressing a chamber that is dealing with a novel idea. Indeed, by dint of Article 10 of the Constitution, which requires all state organs and state officers to make any decisions or apply the law and the Constitution, they are required to apply the Constitution of the Republic of Kenya. That is by dint of Article 1, Article 10, Sub-Article 1. So it should not be lost to anybody that the application of the Constitution in decision-making is entirely in the province of the courts. This Senate, on this particular issue, you are seized of this matter. It is an exclusive jurisdiction that is granted to the Senate to undertake a trial for the impeachment and removal of a deputy governor or our governor or deputy president or president. This is an exclusive jurisdiction that even the courts have spoken about many times. The courts can intervene in limited and justified occasions that merit their intervention. But it should never be lost that this is the trial court, if I may put it that way. And we also come here knowing that the Senate now is a repository of the law in regard to impeachment. All the cases involving the impeachment of governors and deputy governors that have gone to the court have involved the participation of the Senate. So if ever we are to talk about a repository of the law regarding removal of state officers by way of impeachment, it is the Senate. And it should not be lost historically from comparative studies of various jurisdictions why this role in our constitutional design was left to the Senate. It was a decision by the framers of our Constitution that this should be an exclusive matter to be dealt by the Senate. Having said that, I was advised by the leadership of our National Assembly, who are our clients, to read a certain passage from the Bible. I think I have a copy here. Yeah, I'm so sorry. I had to carry this particular Bible. I was so advised. And this is, I read the Bible a lot to myself, but never in this kind of occasion. And this is the book of Exodus 22, verse 22 and 23. And I'll read both the St. James Version, which is the one I prefer because of the language, and from the Living Bible, which is in English is more appropriate. And I read, that is from the King James Version. Ye shall not afflict any widow or fatherless child, and my wrath shall wax hot, and I will kill you with the sword, and your wives shall be widows, and your children fatherless. From the Living Bible Version, it reads as follows. The language is a little bit more palatable. You must not oppress, or you must not exploit widows or orphans. If you do so in any way, and they cry to me for my help, I shall surely give it, and my anger shall flame out against you, and I will kill you with enemy armies, so that your wives will be widows, and your children fatherless. This is the Lord of the Old Testament. Now, I will come back to this matter later. But for now, I want to walk a constitutional journey with the Senate in giving a panoramic view of what our constitutional order is in regard to the office of the President and the Deputy President. Under the old Constitution, we had no provisions that like the ones we have in this Constitution. But this Constitution, and I want to persuade the Honorable Senate, that it does not just address rights as contemplated in the Bill of Rights, but it also addresses fears. Fears out of a long struggle and experience of the people of Kenya. And in the Kenyan people having given themselves this constitution, they were addressing rights and fears And more importantly, they wanted to establish a system of government that can work. And with that, I want to take the Senate to Article 75 of the Constitution, just to draw the attention of the House of the seriousness of what the matter we are dealing with, which is provisions in relation to oath of office of state officers. 74. Before assuming office, before assuming a state office, acting in a state office, or performing any functions of the state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the third schedule or under an act of Parliament. Mr. Speaker, I want to take you to that schedule, and I want to draw a difference, a distinction between the oath of office that is administered to the President and the Deputy President as opposed to the other oaths that are taken by other state officers, including members of Parliament. And there's a big distinction. And when it comes to the oath of the due execution of office for the President and that of the Deputy President, which is found in the third schedule of the Constitution, there are words there that I would plead to the Senate to consider in consideration to the matters which are raised in the motion of impeachment by the National Assembly and the charges as they've been read out here. Now, the motion, the oath for or solemn affirmation for due execution of office for the Deputy President reads as follows. I do swear solemnly affirm that I will always truly and diligently serve the people and the Republic of Kenya in the office of the Deputy President. I pause there to emphasize those words that are found in the Constitution, that I will always truly and diligently serve the people of Kenya, that is the Republic of Kenya, and it continues to say as follows, that I will diligently discharge my duties and perform my functions in the state office to the best of my judgment, that I will at all times, when so required, faithfully and truly give my counsel and advice to the President of the Republic of Kenya, and that I will do justice to all without fear. I emphasize the word doing justice to all. Those three words in the oaths and affirmations for due execution of office, which are found in the third schedule, are not contained in similar words when it comes to the Speaker of the Senate, the Speaker of the National Assembly, the Chief Justice. It only applies to the Deputy President and the President. Why am I saying this? Because if you look at the Constitution in terms of the election of the President and and the Deputy President, you'll find that, Mr. Speaker, sir, that the President and the Deputy President are elected at constituencies. And in that election, they must receive a majority of votes, at least half the constituency in the Republic of Kenya. What I'm trying to say, it has come out, and I say this with utmost respect, that the Deputy President who stands here on trial by the Senate would assume that he was elected to represent the interests of a certain region, whereas the Constitution is clear, is elected by the whole country. He's got no area to protect. Under the old Constitution, the President had to be elected from a constituency, a vice president had to be elected from a constituency as a member of parliament. This constitution has no similar provisions. And now when you come to the functions of the deputy president, and I think this is extremely important in the kind of relationship that there should be between the president and the deputy president, it says so in the following words, which I need to read for clarity, in terms of the deputy president. And those are found in Article 147, that he shall be the supreme principal assistant, deputized for the president in the execution of the president functions, and also he may be assigned duties by the president. The kind of symbiotic relationship that should exist between the president and the deputy president is underlined in this constitution. Now, it is uncontestable, and I think this is the issue that I want to deal with in some detail. It is uncontestable from the record that you have, even from the deputy president, that the words he is accused of uttered, where he alleges that Kenya is like a company existing of shareholders, that does not sit with the Constitution of the Republic of Kenya. Kenya is not a republic that is established on the basis of shareholding. It's a republic of citizens. So when a deputy president talks about taking the interests of Watu Murima, for whatever that would mean, it is not in compliance with his constitutional remit. And the words are there. What he has said in public on this issue is very clear. The second issue is on the question of collective responsibility. You would find out from this constitution that in nearly all the important constitutional bodies established under the Constitution, the deputy president is a member of those particular institutions or organs, like the National Security Council. So one would wonder where even the issue of the Director of Intelligence would be discussed in a public forum by the deputy president when he is the second in command in the National Security Intelligence as established under the Constitution. So I would want, and I plead with the Senate, look at the utterances of the deputy president vis-a-vis his role under the Constitution. And he has even said that where he has said certain things that are deemed to be insightful, that is protected speech. It cannot be protected speech under our Constitution, because under Article 33 of the Constitution, because of what we have undergone as a nation, Article 33, sub-article 2, has a limitation that the expressions that extend to propaganda for war, incitement to violence, hate speech, advocacy of hatred, that cannot be protected speech. Now, the other very important point which I want to put before the Senate, sometime in February 2017, the Deputy President traveled to London, and he went to a hospital in London where his brother was admitted in ICU. When he arrived the next day, he prevailed upon his brother to execute a will. That was the 17th of February, 2017. In that trip, there is no evidence at all that he tried to talk to doctors or physicians who are looking after his own brother. After those visits, he walked away. And 7 days later...
Mr. Speaker, I rise to raise an objection.
Can I proceed?
Mr. Speaker, we owe the Deputy President very elementary decency. We owe it to the Deputy President to be basically decent in these proceedings. I want to know whether counsel at the bar, one, can adduce this kind of evidence that is not contained in any evidentiary material before the Senate. I want to know which ground in the 11 grounds in the impeachment motion is this evidence from the bar supporting. I repeat, Mr. Speaker, we owe the Deputy President the most basic decency. I object.
Senior Counsel Orengo, those requirements, are they contained?
They're contained, they're all here.
And refer to the document.
Volume 4. I am not referring, because if I've got to refer to every document, will take a lot of time, and I have only 30 minutes. If you look at volume 4 of this document on public participation, from page
Volume 4 of the National Assembly.
Of the National Assembly.
Pages
114 to yes, and in fact, this page is also contained the will, and the Deputy President is the one who is relying on this will. The death certificate is contained on page 119, and it shows the only person who attended the deceased, the brother of the deputy president at that time, was his daughter, was the only person present. And then there's the will, and in the documents on page 128, and this is why I was raising this matter. On page 128, there's a letter by Mr. Madenge and Mr. Njoroge Rigeru, who together with Mr. Rigathi Gachagua were the joint will executors. And they're complaining about the conduct and action of the deputy president as an executor of the will and a family member of the late Nderitu Gachagua. On page 129, paragraph 8, there, and it says, from bank statements to this, for this account seen by us, you transferred some funds from this account to other persons as follows. On the date of when Nderitu Gachagua died on the 24th, the deputy president was already withdrawing money. On the day he died, and that day when he died, he was there only with his daughter. And then they say on the 19th of May 2017, again another money was withdrawn and paid to Mrs. Wamuyuro Investments Limited. This story, you will find it in the documentation. And part of it is what Mr. Njomo was saying.
Counsel for Deputy President, just have your seat. When your time comes, you'll be able to make the rebuttals. Proceed, Senior Counsel.
How many minutes do I have?
Mr. Speaker, I respect your direction. I'm willing to take a seat right away, but just to point out something. The document you are being referred to is the document you held in abeyance. Because it was given to us later for purposes of our consideration. That's number one. Number two, Mr. Speaker, you remember that my learned colleague talked about how my client traveled to London, how without talking to any doctor. These are factual claims, Mr. Speaker, that are just coming from the bar. Mr. Speaker, number three, the opening statement speaks to the motion and the grounds in the motion. I beseech this House direct that parties restrict themselves to the motion and the grounds in the motion. The facts you are now being referred to have no basis in the motion and the grounds in the motion, unless Senior Counsel, His Excellency Governor Rengo, can draw your attention to any ground in the motion that those facts are not addressing. I repeat what I said, Mr. Speaker, the ruling is yours. We owe it to the Deputy President and the integrity of our checks and balances institutions to maintain basic decency in these proceedings. I rest.
Counsel, I cannot tell you how you're going to make your opening statements. If you're going outside the allegations, that's up to you. the senators are here listening, and they'll be able to make the necessary decision at the end of it. Now, Senior Counsel Orengo, there's an environment that you've made that the Deputy President of the Republic of Kenya, on a certain date that you indicated, traveled to London.
Yes. The evidence is
his sick brother.
Yes.
And on the side of the sick bed, he made his brother sign a will. Is that contained anywhere in the documents from the National Assembly?
My Lord, Mr. Speaker, if you look at volume 4 from the pages that I indicated, from page 113, it shows what flight he took, at what time, British Airways flight on the 16th, and arrived in London on the 17th. The only business that comes out from that document and his documents is that he got a will signed, and there is no further evidence of his activities in London until 24th, when the only activity in which he didn't participate was to be present when his brother died in London. But all this I'm saying in relation to the allegations that we have against the Deputy President.
Mr. Speaker, sir.
So, Counsel, ordinarily, yes. No objections are raised during the 30 minutes of the opening statement. Ordinarily. I have tried to accommodate, but now you're stretching my generosity a bit too far. Allow Senior Counsel Orengo to conclude. In your opening statement, you may choose.
Now what I want to conclude is this. From what I've said, from the way his brother's account were raided, that was continued to the time when All Life Guidance was acquired for a sale by proxy of 412 million shillings. He bought property in Nyeri, the outspan and treetops for an amount exceeding 800 million shillings. And we're saying part of that money was not money coming from him, and the evidence will show that he was raiding monies that truly belong to the estate of his late brother to acquire property. If that is not an offense by law, these were proceeds of crime committed by the Deputy President to acquire property. And to drive this point home, the judgment by Justice Minor, which is also part of the record, why she made a determination, and that judgment stands, that the 200 million shillings that was found in an account with their financials in excess of 200 million shillings were proceeds of crime. And that 200 million shillings, again, the documentation here, if you look at it and we show it in evidence, was the same money that was used to acquire treetops and Aberdares as part of the money that his sons were able to use to acquire those properties. So we are saying that the acquisition of these properties came out of criminal conduct, and all the particulars of the criminal conduct is found in the documents that were presented before the Senate. Now, Mr. Speaker, I think that it is critical that we look at the authority of the office of the Deputy President vis-a-vis that of the President. The doctrine of collective responsibility. And I showed why the office of the Deputy President is so important in carrying certain functions so long as he lives to the true spirit of the Constitution. Many times, and the incidents have been shown, acts of insubordination, like when he issued a press statement in Mombasa after the President himself had issued a statement that went contrary, absolute insubordination to the President, who is his boss. And if really one can talk about insubordination, that was an act of insubordination. Lastly, the other issue that I need to bring out quickly is that the Constitution and the Senate is aware of the fact that at the end of every 5 years, you pass a basis for allocation of resources here in the Senate. And they abide by certain principles which are contained in Article 203 of the Constitution. This issue about certain areas being preferred because they are shareholders goes against the very spirit of the Constitution. Or the notion that people can be appointed into government on the basis of how they voted or on the basis that they are shareholders, that is not again borne by the Constitution, because the executive authority that is granted to the executive requires that even in allocation of revenue and appointment of people to serve in the public service must depend on regional balance. So to talk about shareholders, to talk about some people being able to reap on the basis of shareholding, that is repugnant and in conflict with the provisions in our Constitution. Now, Mr. Speaker, I would want to say this with all the seriousness it deserves. This Constitution is supposed to work. It's supposed to work. And it can only work if state officers are compliant with the provisions of the Constitution.
2 minutes to wind up.
Yeah. Well, if they're compliant with the provisions of the Constitution, the doctrine of collective responsibility and the authority of members of the cabinet spring from the fact that they are all individually and collectively responsible to the president. If that primary principle cannot be applied, then it will be difficult for any government elected to function in a manner that they can deliver services to the people of the Republic of Kenya. So I urge this Honorable Senate that having painted that large picture, the next phase, when you are now going to listen to the evidence and look at the exhibits that we have attached, you'll find that a strong case has been made out for the impeachment and removal from office of the Deputy President of the Republic of Kenya. And the Senate should not shy away from undertaking that responsibility. It does not matter that there is a matter that could be taken to the DCI or to the AACC. The role of Senate is different. So undertake oversight over those who are given a responsibility to manage the affairs of the country. And that does not depend on the role of any other agency or body created by the Constitution. Your role is to demonstrate to all people in state offices that this oversight role you play, whether it is that of impeachment, to demonstrate to the people of Kenya that it is not cosmetic. And where there's evidence, like the evidence that we are showing and that you see before you, that person,
I'm afraid, Senior Counsel, your time is up.
Should suffer the consequences. I thank you. I thank you.
Counsel for the Deputy President. The floor is yours.
Thank you, Mr. Speaker, sir, and thank you, distinguished senators. My name is Elisha Ongoya. I stand here to make the Deputy President's opening statement. Allow me, Mr. Speaker, sir, distinguished senators, to open by reminding us some fundamental principles. We are sitting here today as a Senate to discharge a constitutional mandate. And before you are given the cudgels to start discharging any mandate in this Senate, the Constitution demanded that you had to take an oath of office before you do anything else. I now understand better why that oath of office was prescribed and why it was framed the way it was framed. The Deputy President reminds you the following terms in your oath of office before you assumed office to discharge the functions of senators. You have to bear true allegiance, true faith, and allegiance to the people and the Republic of Kenya. You have to obey, respect, uphold, preserve, protect, and defend the Constitution of Kenya. And you have to faithfully and conscientiously discharge your duties as members of the Senate. I submit respectfully that the case regarding the proposal to remove the Deputy President from office by impeachment may appear to put the Deputy President on trial, but that is only in the most technical sense of this process. At a more significant level, what is on trial throughout these proceedings is the resilience and steadfastness of our Constitution, our constitutional institutions of checks and balances, and actually their capacity to withstand any form of waves and pressures. That is what is truly on trial. His Excellency Rigathi Gachagua beseeches this House to keep in mind that we have a constitution, a constitutional order, and a constitutional democracy to protect as we conduct these proceedings and as we make decisions in these proceedings. He asks you that at the end of this exercise, let our constitution, our constitutional democracy, and our constitutional order emerge stronger. Allow me to address this House on the defined standard for impeachment of the Deputy President. In a comparable decision by the Supreme Court of Kenya, the case of Honorable Mike Mbuvi Sonko versus the Clark County Assembly of Nairobi and others, the Supreme Court observed as follows, and I quote, "It must, however, be stressed for the avoidance of doubt that the power of impeachment, removal, or recall is not one expected to be in constant or frequent exercise. It is only in the face of credible evidence of extraordinary wrongdoing that the conduct of a state officer will be investigated, and even then, only upon sufficient proof of the allegations that the impeachment, removal, or recall would be warranted." Two questions we pose must constantly linger in your minds, distinguished senators, as you undertake the assignment now before you. Question number one, we beseech you to bear in mind the question: is there credible evidence of extraordinary wrongdoing on the part of His Excellency Honorable Rigathi Gachagua before you? Number two, is there sufficient proof of the allegations leveled against His Excellency Rigathi Gachagua? Article 150, Clause 1, Paragraph B, sets out the grounds for removal of a deputy president from office by impeachment. These grounds are, number one, gross violation of the Constitution or any other law, we emphasize the drafter's use of the word gross. Serious reasons to believe that the Deputy President has committed a crime under national or international law. Again, we emphasize the word serious, then gross misconduct. Surmises, conjecture, street rumors cannot pass muster. This conduct must be the conduct of the person of the Deputy President. It is sufficiently notorious for this court to take judicial notice of when the late Nderitu Gachagua, whose will is now referred to here, died. You are told to investigate the conduct of His Excellency Rigathi Gachagua at a time or at the time around which his brother, His Excellency Governor Nderitu Gachagua, as he then was, died. It is sufficiently notorious that His Excellency Rigathi Gachagua was not Deputy President of the Republic of Kenya. But that's not enough. You will peruse the motion before you with a view to finding which ground in that motion is sought to be established by these allegations around what may or may not have happened around the time the late Nderitu Gachagua died. You will find absolutely no ground supported by those allegations. Let me disclose here. It is designed to whip your emotions. It has no other purpose. Looking at your oath of office that I've alluded to, there is no room for your emotions to be whipped as the basis of decision making in any act that you engage into in the discharge of your constitutional mandate and responsibilities. What does our Constitution expect of the mover of the motion in proceedings of this nature? Our Constitution expects the mover of the motion to make allegations of any or all the grounds set out in Article 150, Clause 1, Paragraph B of the Constitution. And to begin by submitting, it is true that the mover of this motion has written down some allegations in Volume 1 of the documents from the National Assembly. Secondly, the mover of the motion is thereafter expected to supply credible evidence of an extraordinary wrongdoing and sufficient proof of the allegations against the Deputy President. Mr. Speaker, sir, distinguished senators, we submit that is where the mover of this motion ought to start having problems with this House when he's called upon to account. It is the submission of His Excellency Rigathi Gachagua that the motion now before you has fallen short of the threshold set by law by multiple miles. When you examine the material before you, you will discover that it will oscillate between the following categories of stages. One, you will have material before you that just plainly false. Then from falsehood, it will go to the ridiculous ones. And I'll demonstrate that shortly. There will be ridiculous claims here. Then finally, it will end up into embarrassing claims. Allow me, in the few minutes I have, to just do a sneak preview of some of these claims so that we have an overview of the case that is before you. At paragraph 74B of the first volume, which is the impeachment motion, you will find an allegation of this nature that His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local corporate society in Madeira, which they are financially hemorrhaging. Number one, no name of any family member is supplied in the allegation or in any of the evidentiary documents before you. No name of any ally is supplied in the motion or in any of the documents before you. No name of any associate is supplied. A false name, none, is supplied in the motion and in the documents before you. No name of any proxy is supplied in the motion or in any of the documents before you. The name of the alleged circle is not identified. You can imagine, Mr. Speaker, sir, distinguished senators, being called to defend yourself on a claim that you have taken over through your associates a circle that we don't know. Told, now come and defend yourself. I began by saying some of these claims are either ridiculous or embarrassing. Secondly, at paragraph 74A, you'll be told that His Excellency has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that would benefit tea farmers. No statement, no affidavit, no correspondence from any official of the Kenya Tea Development Agency is before you. No complaint to any agency, no complaint to this parliament by any official of the Kenya Tea Development Agency is before you. It's just a claim which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution, he told the National Assembly, just believe my word for what it is. And when we thought that was a joke, we got a joke lifted a notch higher. The National Assembly actually just believed his word for what it is. No evidence. Nothing in the affidavits before you addresses anything about the Kenya Tea Development Agency. Nothing in the 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states that His Excellency has persistently undermined, demeaned, and committed insubordination instead of assisting the President. And let's face it, Mr. Speaker, sir, distinguished senators, if you accuse somebody of insubordination, the only person who can complain of being insubordinated is the supervisor. No statement from the president, no affidavit from the president, even no witness summons to the president has been sought here. To call him to complain, he has been insubordinated. The deputy president, when he received this motion, wrote to the secretary of the cabinet, requesting to be supplied by all assignments given to him by the president and any that he has not delivered. To date, as we stand here, we have not received a response to that letter. And yet we shall be told, just believe the move of this motion, the member of parliament for Kibwezi West constituency, that when he is oscillating between the National Assembly and Kibwezi West to serve his people, he knows better than the supervisor of the deputy president that the deputy president has insubordinated his boss. I began by observing they will move from the false through the ridiculous to the embarrassing, and these are the claims before you. At paragraph 64, paragraph A of the impeachment motion, you will be told that His Excellency the Deputy President said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. Mr. Speaker, sir, my eyes are normally problematic, so I will not know the time allocation.
minutes.
Thank you so much, Mr. Speaker, sir. The claim is that His Excellency publicly said that he would present a petition for the removal of Justice Esther Maina from office, which he has not done to date. That's the complaint. Evidence is before you that there is a pending complaint by His Excellency the Deputy President before the Judicial Service Commission. So the mover of this motion first has perjured himself in his affidavit by saying that each of these facts are correct, when this fact is false by evidence available. You will find that paragraph 34 of the motion before you, it says that His Excellency falsely threatened to file a petition for removal of Justice Esther Maina. How can the Deputy President be accused of falsely threatening when in fact he has filed the complaint? Where is the falsehood when there is a pending complaint? That complaint is before you in the Deputy President's documents for your own perusal. I began by saying they'll move from the false through the ridiculous to the embarrassing. At paragraph 78C, you will be told that His Excellency routinely summons procurement officers in ministries and state institutions and instructs them to direct procurement of goods and services in a specific manner. No officer from any ministry will swear an affidavit claiming to have been summoned to award any procurement for any goods or any services in a particular manner. In fact, what you will have before you is actually very ridiculous. You will be told that there was a tender for supply of mosquito nets that was cancelled in May 2023. Then a local company that was an agent of the supplier was following for the return of its bid bond in July, 2 months after the cancellation of the tender. How can you influence a tender that was cancelled 2 months ago? I told you it will move from the false through the ridiculous to the embarrassing. Now, the more interesting one is at paragraph 78A. You'll be told that His Excellency bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited. Good people, Crystal Limited was not even a bidder for that tender. He pressurized people to award it to someone who is not even a bidder for that tender. I observed it will move from the false through the ridiculous to the embarrassing. Those of us who understand this motion for what it is, understand why these panel beating maneuvers are being tried here. The motion as presented and approved by the National Assembly will remain in our constitutional history as the most embarrassing motion ever approved by a House of Parliament in the Commonwealth. We respectfully submit. You will be told at paragraph 58 that His Excellency is reasonably suspected to be the principal beneficiary of what are called dubious transactions by Lusona Events Limited. You will then go to the allegations on Lusona Events Limited, and you want to see those transactions, how are they terminating to the Deputy President? You'll not come across any connection. They'll just say, a director of this company withdrew some money from his own company, the Deputy President director, none of his family members are director. That person withdrew money from his company, bought a motor vehicle in his own name. The mover will say, I'm therefore drawing a reasonable conclusion that the Deputy President is the beneficiary of this. Good people, the word reasonable has meaning known to law. I submit very respectfully that this falls short of the definition of the word reasonable suspicion. I submit it actually gravitates towards unreasonable suspicion. Now let's look at this. You'll be told that His Excellency has acquired 40 acres of land in Kakuret, Kambraini in Nyeri. Evidence before you will show that this is land that the Deputy President in fact bought from a current member of the National Assembly. So he knows that member. In 2015, before he even joined state office as a member of Parliament, you are told that the purchase of this land in 2015 shows that in the last 2 years, the Deputy President has amassed immense wealth. I began by saying, let's be elementarily decent. One of the most frustrating things about preparing for such a hopelessly conceptualized, hopelessly crafted, and hopelessly presented case is that you begin doubting yourself because you begin wondering, what am I not seeing? Land bought from a sitting member of the National Assembly in the year 2015 is supposed to be evidence that in the last 2 years, His Excellency Rigathi Gachagua has amassed immense wealth from the office of the President to acquire that property. Now, let's look at paragraph 45G. You will be told that His Excellency has acquired 80 acres of land in Meru County. No land registration number is provided. Not even an affidavit of a neighbor who says, I know yes, this land is my neighbor. Just an allegation by the mover of this motion like that. And the Swahili say, ukistaajabu ya Musa utaona ya Firauni. this mover of this motion stood before the National Assembly and said, just believe me for this statement as it is. The first joke. The second joke, the National Assembly actually believed him and approved the motion. You'll be told that paragraph 45H, that His Excellency has acquired a dairy farm in Nyandarua County. Now, I guess we all have a common understanding what a dairy farm is. His Excellency has no dairy farm in Nyandarua County. The move of this motion does not give us any evidence of this dairy farm in Nyandarua County. You'll be told that His Excellency has used the office of the Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa. What will shock you is this, good people. The contract for the renovation of the official residence of the Deputy President was signed by the controller of State House. Unless the move of this motion wants to make a claim that the Deputy President conspired with the State House to have this contract executed. Number two, it will be known to all of us as members of Parliament that the money for renovation of this official residence was approved by the National Assembly. Is the National Assembly conceding that it approved the money for unnecessary expenditure by government? How can the National Assembly approve money for use for renovation of the residence of the Deputy President, then after that money is used for the intended purpose, the renovation of the official residence of the President, now drag the Deputy President for impeachment for the reason of that renovation? I said it will move through the ridiculous to the embarrassing. You'll be told that the Deputy President has a helicopter landing facility at his land, Ruguru, Kiamariga, 1223 in Madeira. The Deputy President simply has no helicopter landing pad on that farm, a small parcel of land with the napier grass, unless the mover of this motion can now convince us that new technology has emerged, that napier grass is the constructing material for landing pads for aircraft. That's the only way it can make sense. But because it doesn't make sense, good people, you'll agree with me, it moves from the false through the ridiculous to the embarrassing. Now let's deal with it. You'll be told the Deputy President has amassed a wealth portfolio amounting to 5.2 billion shillings. Elementarily, we must then look at the particular